Hello, Assalamu alaikum. Bismillahirrahmanirrahim. I am Dr. Javed Iqbal Khokar, Professor of Forensic Medicine and Toxicology. As we are discussing law related to medical men, and this is the fourth lecture of this series. And in this lecture, I will be discussing dying declaration. And the contents of today's talk will be that I will be discussing what is dying declaration and who will record it, and what is the level of admissibility of dying declaration. Then I will be also discussing the dying deposition and what is the admissibility of dying deposition. So starting with the topic of today, dying declaration. This is the declaration of a dying person in his own words, that how he has arrived into this situation. Dying declaration is recorded only when the clinical condition of a victim of physical assault is so precarious that his death is imminent. He may be the only witness and there is no time to arrange for the deposition. Any credible person can write down the evidence about the circumstances leading to his condition as dying declaration. Doctor on duty, being the in charge of the patient, would be the best choice to record the declaration. Doctor should not hesitate from the legal duty. He is the best judge of the situation and about the physical and mental condition of the patient. Admissibility of dying declaration is subject to the condition that the victim is the only witness and if he dies cannot be produced in the court. So there is an assumption that a dying person cannot tell a lie, and impending death compels the injured to speak the truth. Dying declaration is valid only after the death of the victim. But if the victim survives and after recording the dying declaration, then it will not be valid, because now he can appear in the court and can record his evidence himself. Now the dying deposition. When an important witness is suffering from serious illness and he is unable to come to the court of law, the court then goes to him to record his evidence as dying deposition. All the arrangements for the recording of evidence are made. Both sides counsel, accused, and the victim with full opportunity of cross-examination is given. Now the difference between dying declaration and dying deposition. The declaration, its legal formalities of oath are not necessary in the declaration, whereas in deposition, the oath is essential component. The declaration can be recorded by any credible person including doctor, whereas the deposition is recorded by the judge of the court only. The presence of accused is not necessary in dying declaration, where in deposition the presence of accused is necessary. In deposition, the case must be criminal and death of the victim is imminent, whereas in deposition it can be recorded in any case, whether civil or criminal, when the victim is critically ill. It is the statement of dying person in his own words and nothing else in dying declaration. Whereas in deposition, it is the statement of a dying person and the cross-examination by the accused. In declaration, it should be read over to him and may or may not be signed by him. Whereas the dying deposition, signature of the dying person is necessary. In dying declaration, after recording, it must be sealed and sent to magistrate, whereas the dying deposition, all the recordings are being made by the judge himself, and it becomes valid only when the death of the person. The dying declaration becomes valid only upon the death of the person, whereas in deposition it remains valid even if the person survives. So the summary of today's lecture is that we have discussed about the dying declaration, and we have discussed who will record it and what is the admissibility of dying declaration. We have also discussed the dying deposition and the admissibility of the dying deposition. Thank you very much. Take care. Allah Hafiz.